The care sector is a workforce that's hugely international and diverse, and it's lived through the twists and turns of privatisation and subcontracting. It's been on the front line of electronic monitoring, and now it's the site for what could well be a very pioneering innovation in the regulation of work in the UK.
There's obviously a big impetus to have an employment bill, but it is the sort of big shot that we're going to get at this. And I think it's very important, even if clauses aren't necessarily drafted exactly as they will be in any secondary legislation, they have got to incorporate everything you need to pull the right levers and to get you where you need to be.
Hello to all our listeners. My name is Carolyn Jones. I'm Senior Vice President of the Institute of Employment Rights, and I'd like to welcome you to this, the second episode of IAR's new podcast series. In our first podcast, John Hendy and Keith Ewing looked at the ideas behind the Labour Party's proposals to make work pay. Since then, the Employment Rights Bill has been published, the first piece of labour law introduced by a Labour government since the 2008 Employment Act. What do we think of the new bill? Is it a hit, or does it, as one trade union leader suggested, have more holes in it than a Swiss cheese? Today, our speakers will look back at lessons to be learned from the implementation of previous Labour government legislation and forward to how this new bill might perform. To steer us through that discussion, we are joined today by an IAR Vice President, Lydia Hayes, Professor of Labour Law Rights at the University of Liverpool, and by Sarah Veale, an IAR Executive Committee member who for many years was head of the Equality and Employment Rights Department at the Trade Union Congress. Turning to you first, Sarah. In recent weeks, the IAR experts have been in discussion with government officials tasked with drafting the Employment Rights Bill. In your past role at the TUC, you had similar discussions with civil servants under the Blair and Brown governments. We wondered what insights you could share with us about that whole process and if there are any lessons to be learned from it for our current discussions. What do you think?
I think there are lessons to be learned, and I understand the Swiss cheese comment. We perhaps had slightly the opposite problem last time round with the Employment Relations Bill, because what we found to be initially quite a straightforward proposition that where the majority of workers supported it, unions would get statutorily backed recognition rights. And we ended up with one of the most fiendishly complicated pieces of legislation, I think, still on the statute book. The shock that I think we went through at the TUC was the whole convoluted process of having three parties involved in discussions and hardly ever being given the opportunity to all come in together to have those discussions. So what emerged and was very difficult to deal with was a lot of parallel lobbying. And what we would find is that we would talk to government special advisors, civil servants, and we would think we'd got something agreed in terms of exactly what was going to go into the bill, only to find out the next morning that a nameless Labour peer had been whispering into the ear of the Employment Secretary and the Prime Minister, and we would suddenly be told that what we had thought had been nailed down and agreed was in fact to be heavily qualified because of concerns of the employers, the CBI principally. And that was a really difficult way of conducting any kind of meaningful discussion because we lost trust in the government, or certainly that bit of the government, quite quickly. And I think the CBI felt that they were leading the charge and that if they made enough fuss about something, it would mysteriously be, to put it charitably, watered down. That's one of the searing memories I have of going through with quite a lengthy process which led to the Employment Relations Act of 1999. I think one or two other things that came out of it for us and for me was, first of all, what I call weasel words. So we had understood that we were going to get, for example, the right for a worker to be represented by their trade union in a grievance or disciplinary hearing. And what suddenly emerged was this extraordinary word accompaniment, which sounds a bit like someone playing the piano while you sing. But it was quite clever because their lawyers had worked out that if you had someone accompanying you, a companion, they didn't have any of the rights that a trade union representative would have had to intervene on your behalf if necessary, to speak on your behalf. Trade union people who went into those procedures then found themselves with a very passive role where they were very strictly limited in terms of how active they could be in defending the members' interests. And that was all because the wording was changed right at the last minute, but very significantly. And on the back of that, I would say it's absolutely critical to have good, friendly, experienced legal eyes working with you all the time to make sure that you're not missing tricks and that you're understanding exactly what the consequences will be of particular bits of wording. And the last thing I'd say in this context was that there are all sorts of philosophical problems, actually, because the government was wedded to this term fairness at work, balance, which all sounds fine. But we discovered that for them, that meant balance as of that day and didn't take into account the fact we'd lived through years and years and years of Tory government who changed and changed and changed the way in which trade unions could operate and indeed workers' individual rights. So what they thought was balancing fairly was actually not taking account of the fact that the pendulum had swung so far against workers by that time that you really needed to be able to take balancing measures to get you back to a place where you were, in fact, playing on an even field. And that was immensely frustrating because we felt that we weren't even really on the same page as them some of the time.
And that's kind of an unintended consequence of the legislation that was introduced. Do you see any in this employment rights bill, any kind of possibilities, areas where, again, we might see unintended consequences, either negative or positive?
I think there are all sorts of areas where there are potentially going to be problems. If you put all your eggs in one basket and you just have one piece of legislation, inevitably it's going to be cut up into pieces. And I think you get to the stage where it's absolutely critical to get as much as you can onto the face of the bill, because otherwise things get missed and you'll never get them back again. There's obviously a big impetus to have an employment bill, which is very creditable, but it is the sort of big shot that we're going to get at this. And I think it's very important, even if clauses aren't necessarily drafted exactly as they will be in any secondary legislation, they have got to incorporate everything you need to pull the right levers and to get you where you need to be. And that's where good lawyers come in. Because if you don't have the wording right, if you miss something, if you push something into secondary legislation that ought to be on the face of the bill and agreed and nailed down, that will condition the way the secondary legislation develops. So that's the lesson we learned rather too late. And the unintended consequences with the Employment Relations Act were that we had a whole load of new things introduced at the bill stage, which had much worse consequences than we feared at the time. I suppose, on the other hand, there were some bits of legislation that turned out to be rather more effective than we'd thought they would. Just to give one example, the part-time work regulations, which actually came from the EU, which had been negotiated by the European TUC and was a good piece of legislation and was more or less copied out as it was, we didn't realise the extent to which that was going to give better rights to part-time women in particular. And what the government hadn't spotted that we did spot and that we used to the 99th degree was that when you're talking about equality in terms of pay, that includes pensions. And what they hadn't realised or hadn't thought through was that these new rights were going to apply to people's access to pensions, which part-time workers in the public sector as well as the private sector had been unlawfully excluded from. And it also gave us a chance at the TUC to run a long case, actually, against the government about refusing to accept that if you're going to compensate people for not having let them have access to benefits, you've got to look at the past, because obviously you can't say, well, you weren't in the scheme, so we're only going to pay you from X onwards. You had to look at when they were eligible to join the scheme and say, well, obviously you would have joined had you been able to. Therefore, you're owed back pay and payment into the pension scheme from the employer to make up for the years you were excluded. So that was a huge victory that we didn't foresee, which I think actually really well illustrates the importance of getting the legislation on the statute book in the way that you want it, and then creatively using trade union strength for negotiating better deals, and also trade union-led litigation, which we used in order to push the issue as far as you possibly could.
Having looked at the bill, an initial look over the bill, do you think there are particular parts of the bill vulnerable to employer pressure? And how might the unions best respond to that, and even the government? Do you think they will? Is there a political will to resist what the employers are saying? No, what's the balance there?
The employers, they're already making a fuss about some parts of the bill, and you can see how some parts of the bill could end up being quite seriously weakened. We were told we were going to get a ban on the use of zero-hour contracts, but it already looks as though there are signs of employers saying, well, hang on a minute, some of our workforce like those, why can't we go on using them? Now, if you talk to the unions, there are strictly limited areas where zero-hours contracts are not objected to by employees on the whole. The trouble is the employers have used that as a battering ram to have a whole area of exploitation where they force people onto these contracts who should never have been on them. And there's going to be a massive job of work, I think, by the unions and the TUC to squeeze out the legitimate areas, and hopefully those would only be in kind of unionised areas so they could be properly monitored. But to make the case with case studies, careful examination to show that if you don't have something written down and you don't have really strict parameters, these things are just not going to be accepted by and large. The default is going to be that you don't use zero-hours contracts. And where you do, it's got to be really, really, really tight and strictly policed and controlled. Another thing I think is in danger of some slippage is the hire and fire stuff. I can see that hire and fire, again, is going to be something where employers will say, but hang on a minute, if someone's behaved appallingly, I've got a right to get rid of them. But of course, yes, they have got a right with due process to do that. But on the other hand, what you can't have is this increasingly common practice of getting rid of people and hiring them back in the next day on a much lower wage and with much worse working conditions, often on the transfer of a business. So I think all those sorts of things are potentially difficult to get through in a bill without being knocked around and quite significantly reduced.
One of the things we're looking at is the unintended consequences of introducing day one rights before you introduce single status of worker.
Yes.
Because all that will happen is you will say that there are day one rights there, but actually employers will find that gap in the legislation and put everyone onto a contract that means they're not entitled to it. Turning to you, Lydia, and looking at some of the details of the bill. In 2017, Lydia, you authored the IR's excellent publication, 8 Good Reasons Why Adult Social Care Needs Sectoral Collective Bargaining. Tell us a bit about how those ideas in that publication have come to be expressed in the Employment Bill as a strong pillar of Labour's legislative agenda in government.
Yeah, thanks, Cad. The bill sets out a plan for an adult social care negotiating body. It's a radical part of the bill. It's perhaps, certainly for me, it's the most exciting part of the bill. But as you say, it's something that I've been working with and in the context of for a very long time now. But it really is radical. It offers so many potential opportunities for the future. And radical changes to law that shift away from the status quo, they don't come out of thin air. They take years of championing ideas and careful research and evidence and compelling argument and consensus. And thousands of people have taken up and advanced the case for sectoral collective bargaining in adult social care. Early adopters include Unison in the Northwest, the network of care workers led by a Unite Shop steward in Manchester, the GMB, Unison's Community Sector Conference and their delegates, the Wales TUC, the Scottish TUC, and many, many more. And care workers up and down the country have organised meetings, they've engaged with MPs, motions were argued for and carried at the TUC, at Labour Party conferences, and initiatives have preceded this that have been taken in Wales and Scotland, and they've been really important. The Social Care Fair Work Forum in Wales supports collective bargaining and uses partnership between unions and employers to address issues of terms and conditions. This initiative, which has grown out of research with care workers, the publication of Stories of Care, which was the initial book, which showed that chronic problems across the social care sector could be traced back to inadequacy in employment law, particularly in individual employment rights. And the publication of the IER booklet, 8 Good Reasons Why Sectoral Collective Bargaining is Needed in Adult Social Care, that was given life and meaning, and it's been refined and debated by thousands of care workers and their representatives before we got to this point. So it's gone from the Labour manifesto into the new government's agenda. It is a radical departure from what's gone before, and it is great to see this as part of the draft bill in the first days of the Labour government. Of course, there is so much work now to do in terms of how discussions will unfold in Parliament, ongoing consultation, and of course the important role of the Secretary of State in devising regulations and drawing together the negotiating partners. So there's an awful lot to do, and that gives it so much strength.
Unity in action from the unions. We can't always say that, but that sounds very positive. And I'm sure, as you say, that is very much a radical move in terms of political policy. Having said that, the original Labour Party proposals in a New Deal for Working People was to roll out sectoral collective bargaining across the economy. That's now been reduced to social care. Do you see it getting rolled out further? And is this a model that can be used for others? What do you think?
Yeah, so when I say it's radical, that doesn't mean that in and of itself it's enough. Yeah. It's not. When I say it's radical, what I mean is that it represents a turn in the road in relation to how terms and conditions in the care sector are going to be deliberated, negotiated, bargained for, and the status and role not only of trade unions, but perhaps more fundamentally, the role of care workers' own voices in the development of this sector, which is so critical to so many areas of social life, our economic well-being, our ability to be able to support an ageing population in particular, our ability to realise the human rights of people with disabilities, to develop the NHS in a way that's fit for the future, where people can depend upon good quality care that comes from good quality jobs. And so that's the radical element, is the way in which this proposal says we're not going to look at this issue only through the lens of individual rights anymore. We are going to take this leap to where the evidence shows us is rich and fertile ground for the development of terms and conditions. The regulations set out the establishment of a negotiating body for adult social care, which will be comprised of representatives from trade unions and persons representing the interests of employers. That the negotiating body will address pay, terms and conditions, and other specified matters relating to care workers' employment. And the bill also includes a definition of care workers, which has a broad enough scope to encapsulate all persons who are wholly or mainly employed or are employed in connection with adult social care, including personal care and practical assistance for those who need care and support. So it looks on my reading that this includes personal assistance, which is a really important area. So we'll be aware that adult social care is quite a fragmented sector. But what unites it is the fact that in many different ways and through many different skills and at many different levels, this workforce are united in delivering on human rights to care and support, and united in delivering the public obligations and the public duty that exists for care needs to be met. The provisions that are set out in the bill also include the need for regulations about the ability of the Secretary of State to refer matters to the body for negotiation, and the powers of the Secretary of State to refer the fair pay agreements back to that negotiating body if the Secretary of State thinks that they need to be reconsidered. the Secretary of State can intervene, and the Secretary of State also has power to ratify those agreements so that the effects are binding, so that where those agreements are ratified, issues in relation to pay and new rates and provisions in relation to pay will take effect across the whole sector. And in other matters, the agreements will be implied into contracts. And I think that people have a tendency to underestimate the care sector. The care sector and care workers are often stereotyped and marginalised as people who are on the periphery of the labour market. But that's so wrong, because adult social care is actually a bellwether sector. Care workers have been some of the lead claimants in some of the most important legal decisions over the last 30 years. They've been at the forefront of advances in equal pay law through the courts. The care sector is a workforce that's hugely international and diverse, and it's lived through the twists and turns of privatisation and subcontracting. It's been on the front line of electronic monitoring, the mainstreaming of 0 hours contracts in the sector. It's also been at the forefront of union renewal and new organising strategies. It's been on the front line for the nation during COVID. And now it's the site for what could well be a very pioneering innovation in the regulation of work in the UK. And I think that's exactly where it ought to be.
And will that be a model and cover all the points that could be rolled out to other sectors, do you think?
Oh, absolutely not. The point that I was making about the collective initiative that sits behind these provisions in the bill is so important. We must not assume that from these seeds there will be new plants, new areas of sectoral collective bargaining that will grow. It has to be organised for, it has to be campaigned for. And it also needs to be recognised that sectoral collective bargaining is first and foremost sectoral. The arguments in support of it need to be sectorally specific. Now, of course, it represents legal entitlements in international law for all workers, but the realisation of new machinery in the UK for sectoral collective bargaining means that we need to think strategically and carefully and in an organised way about building research and arguments and campaigns for sectoral collective bargaining in other sectors, not to wait for an assessment of how things turn out in adult social care, because adult social care is sectorally specific. Now, many of the arguments around which sectoral collective bargaining in adult social care have been established do apply to other sectors, but in terms of the detail of that, the experiences of the workers actually engaging with workers and campaigning with workers for their empowerment, for their voice, for them to have representation through sectoral collective bargaining. It needs to be done with workers rather than for workers. And that is absolutely critical. And I know that unions will be beginning now to think about those sectors where there are strong cases for sectoral collective bargaining to address really deep grievances and problems that exist within particular labour markets in particular sectors, and to see that giving workers a voice and an involvement through sectoral bargaining to reach agreements and standards through negotiation is the way forward.
Obviously, there is work to be done on spreading out sectoral collective bargaining across the economy. In the meantime, there are many workers living in poverty, living without security, and who are too scared to speak out and demand more in their workplaces. The Employment Relations Bill contains a number of new employment rights. Do you think the balance between individual and collective rights in the Employment Rights Bill strikes the right balance? Sarah?
I can see potentially, if it's not carefully done, competition between the two things. You can see theoretically a situation where a worker decides that they don't think they've been paid the same as someone of the opposite sex, would they be able to take individual litigation, or would the collective bargaining system mean that it would have to go through a different route? And I can just see potential tension between individual rights and what the union's doing, and also potentially a bit of a difficulty between sectoral collective bargaining on the broadest sense and enterprise level issue solving. I could see how the two things may sometimes rub up against each other.
I also find it a difficult question to answer because for me, the individual rights are simply not brave enough. But at the same time, I know that individual rights are not the answer for remedying the lack of power that workers have within workplaces and across the economy. It's not the remedy for our chronic productivity issues in the UK, and it's not the issue for the chronic ill health which is now connected to poor quality work across the UK. That's not going to be fixed through individual rights. For me, the real meat and potatoes of this bill is in repealing some aspects of previous trade union legislation that have been very restrictive, the support for sectoral collective bargaining in social care, the new rights for trade unions to have access in relation to workplaces, and hopefully those measures can be built upon and improved further. Individual rights, I think that there are some difficulties. For example, the elements in relation to 0 hours contracts and how those are going to be managed. Whilst I appreciate Sarah's point about how important it is to get these things into the bill and then to work and refine them, I am concerned that the measures in relation to 0 hours contracts are so complicated that what will happen is that employers will revert to employment through agency work, that they will make increasing numbers of workers believe that they are self-employed. And we have to expect that because the labour market is dynamic. It never stands still. And this is one of the problems that we always have with individual rights, is that we are legislating for addressing issues which are to do with inequality of power and about values such as fairness and voice and equality. And as soon as we intervene in one area, then the labour market dynamically morphs into different forms. And that's one of the key reasons why bargaining and negotiation by unions and employers in particular sectors is just so important, is to be able to keep up with that dynamism and not to provide remedies and solutions after harms have happened to workers, which is often the role that individual rights play.
We are caught between the dynamic developments of the labour market and, as Sarah pointed out, the hostility of some employers who are always determined to find their way out of legislation.
Even collective legislation. I mean, that's unfortunately the Employment Relations Act and the implementation of the statutory recognition scheme shows, I'm afraid, how easy it is for employers to create loopholes which unions can't plug. And also, we're going to have the new agency, aren't we? Which one would hope would start in itself to lend itself to more collective solutions. Because if they look at systemic low pay, they ought to look at whether the national minimum wage is being properly implemented. Individual cases, as you say, Lydia, just don't really do very much. They compensate the worker, which is important. But equal pay is a good example where you have to take individual cases. And I remember running shed loads of cases, trying to pull them all together into one case and saying in the intermediary stages of the employment tribunals, look, this is about a collective issue. This is systemic unequal pay. It's not just about 3 women who got their pay not properly compared to the male comparator. This is a massive systemic problem in this sector. But no, you had to chip it away with it with loads and loads of individual cases. And that allows employers to escape. They just get rid of that problem, pay them off, and then carry on doing much the same thing. 100% agree with you that workers' power is the key to this. You've got to rebalance the economy and rebalance the labour market so that workers' power through trade unions is what determines the employment relations and the way in which industry is developing. That's really the only secure way. We have to bite their hands off for good individual rights, because you have to. And there are, sadly, a lot of workers at the moment who are here, there and everywhere. The labour market is fragmented. They're not covered by collective bargaining. They're not in unions. And all they have is the right to claim unfair dismissal. So it's important to make sure they have that right as soon as they start the job. But it's not going to solve the problems. I absolutely agree with that.
Even with collective bargaining, if you haven't got the right to strike to back that up, and there's none of that within this legislation so far. Having said that, there is scope for manoeuvre still, I think. One of the accompanying documents that came out with the Employment Rights Bill was the Next Steps document, which does highlight certain areas where further discussion, further consultation, further thoughts will be published as we go on. So there is room for trade unions to manoeuvre. There is gaps that we can fill, so I'm sure you two will play a central part as ever in developing those ideas. So thank you for your thoughts here today. I think we've come about to the end of our time for this session. So can I just say thanks to Sarah and to Lydia for sharing their knowledge and experience with us today. Very interesting. I need to say too, thanks to Thompson Solicitors for sponsoring this podcast series. I would encourage listeners to visit their website. It's full of information, full of briefings, full of ideas on how this situation can be improved. And thanks to the listeners for being part of our new podcast initiative. There's plenty more to discuss, as we've found today, in future episodes. So please join us and be part of that debate.